You will recall that in July, we passed bills that had very aggressive timeline for implementing some of the changes to the IHSS program. One of those involved provider enrollment, new orientations and such. And the deadline that we were advised by finance and others that could be met at that time was November 1. However, November 1 has come, and if most of you, I imagine at this point, have heard from your counties, every county in the state is having major difficulties implementing this. We had a hearing last week, some of you may have seen, the Assembly Budget Committee that some of us also attended, where we asked the department, well, when are you going to finish this process and how do you finish it? And you know, the normal way the Department of Social Services has worked in the past, they convene with stakeholders, they talk to the counties, they work with them to figure out how to implement any changes to these programs. In this case, they are not doing that. They have not done that. And every county in the state, we have letters from most of them, are saying this is causing huge hardships, not only to the county and its staff to try to do something they can't do, but in fact to our individual constituents who are unable to then have providers help them. There is no new providers being enrolled because the department has not provided with the counties with the materials they need. They don't have forms in languages other than English. They don't have a lot of the things that counties have needed to do this. So it's clear that while they attempted to be aggressive, the all-county letters, some of them, the counties will argue, put them in positions of legal liability because they're changing the way people are doing business, and they haven't consulted sufficiently. It was very clear from the hearing last week that that's the situation. So this bill would require the department to enter into the stakeholder process, require that at a minimum it be completed by February 1. They told us last week they could complete all of this, you know, this week. If that's true, they can notice us this week and the whole thing can go into effect 60 days from that. This bill says they must convene that process, they must give us notice, and then the program would be implemented within 60 days of that occurrence. It is extending the deadline. I understand the concern that it will erode savings, but frankly, member, if those savings are based on the theory that people should not have care because we can't actually enroll any new providers in this state this week, that is not the best way to go about it. We need them to be efficient, but we also need them to do it in a way that our counties can actually implement. They don't have any instructions, they don't have the materials, they don't have the contracts and resources to do the background checks that are required. Their guidance conflicts with current law, and the counties are very concerned about liability in those instances. They just need more time, members. DSS has argued, although we argued in the Budget Committee last week, that we thought they could do it on their own. They could delay the implementation whatever time is necessary in order to actually get all the pieces in place for the counties. They have said they don't think they can do that without statutory authorization, and therefore this bill, Ms. Evans presented this bill and it passed out of the Assembly on a 68-0 vote. I'd ask for your aye vote. Thank you very much. Mr. President, I appreciate the debate, and I certainly appreciate the concern that there will be an erosion of savings, but to be honest, I'm not sure many of us believe that there were savings associated with these programs. If you ask the counties, I think they'll tell you these so-called reforms will cost more than anything else. What this will not undermine, and I appreciate Senator Hollingsworth's point, but this does not change the existing underlying so-called reform that was made to require the providers what they're not implementing, the portion that hasn't been stopped by the court. This is just the piece that they were supposed to implement by yesterday. Requires completion of a new provider enrollment form, submission of fingerprints and background checks, attending provider orientations, and signing an agreement. All of those things can and should be done, and Senator Dutton is probably right. The department can and should have done this. Now, whether the third furlough day interrupted that, you know, that's an excuse we've heard a lot this semester. You know, who knows why the department wasn't able to do this, but the truth is the department has not met its obligation. And the question before us, members, is whether they're going to ask the people that Senator Alquist and Senator Leno described, if you've seen the flyers that are coming around from the individual cases in counties where people are being hospitalized because the county is unable to enroll new providers. So what we're going to have, members, if we do not pass this bill, is a situation that for the next 2 or 3 months, while the department tries to get it together and the counties then try to implement whatever it is the department comes up with, that we will not be able to enroll any new providers, and anybody who comes in and needs a new provider in this system for that period of time, whatever it is, will not get one. We will be paying for that, as Mr. Wright points out, in Medi-Cal dollars. We will be paying for that in nursing home costs. We will be paying for that in a variety of ways. And this is not encouraging them to drag their feet. The administration does need to be held accountable here, but they need to be accountable by getting it done and doing it right. And the people who are going to pay the price here are the counties and our constituents who need the services and who wish to be those tax-paying providers that Senator Wright was talking about. These are people that want to work, that want to do the right thing, that are happy to provide the background checks. That I don't think any of the actual requirements of the legislation are what's causing the problem here. It's how do you implement it in a fair way that's not going to get counties sued? How do you do it in a way that allows county workers to catch up and do it right and provide the orientation when the department has not provided them with the materials? It's just common sense, members. We cannot require people to do something that we're not providing them the tools to do. Now, granted, I would love to receive that letter next week and say, we've done everything we need to do, and now the 60-day clock runs and the whole thing will be implemented by January. That's the way it ought to work, members. But that's not what we're seeing today. And if we don't give them this opportunity to implement the way it can and should be done over the next 60 days, then we are going to see more and more cases of suffering, and we are going to continue to hear from counties that it's simply impossible to do the job without support and a proper direction and guidance from the Department of Social Services. I agree that services should have been clearer about what they were doing, and it should have been clear to us earlier. They should have talked to the counties. There's a lot of should-haves and could-haves here, but the bottom line is that today, counties cannot do this. They are required to do it as of yesterday, and we are getting no new providers enrolled in this state until the department straightens this out. You know, we can all hope that that'll be before Christmas, but you know, this bill will give them until, with a date certain, February 10th to February 10th or 1st to do so. I don't think that's an unreasonable period of time. Better to get this right, get the long-term savings, if there are any savings to be had from these so-called reforms, then those savings will be in the long term. It does not change the underlying policy. I'd ask for your aye vote.